Hello there, and a very warm welcome to yet another scintillating edition of the program CAC Weekly. Now, CAC Weekly is that weekly program that keeps you abreast on the activities and the achievements of the Corporate Affairs Commission. I am Amina Jibril. Coming up on CAC Weekly, as CAC begins striking off dormant companies from the register, we x-ray the entire process. Plus, we bring you tutorials on how to register a company online unaided. All of this will be right after this break. Do stay with us.
The issue of mandatory columns and how to distinguish one beneficial owner from the other. Some jurisdictions have unique identifier for each beneficial owner. So that similar to what companies have, every company has its unique apps. They have introduced the use of unique identifier for every beneficial owner. So that if you are multiple beneficial owner, all you need to do is once you enter that unique identifier, it will populate the details of that face across the different entities. So our register is new. So these are things that we are considering for the future. But we want to see how this can best serve first before moving to that hybrid issue of unique identifier. Another issue we are considering is we are going to remove the email address from the public register.
Welcome back to the program. Now let's begin. You may recall that the CAC began the implementation of the Companies and Allied Matters Act, CAMA 2020, in January 2021. Now, the landmark law, alias the game changer, gave the CAC the leverage to implement far-reaching reforms for the benefit of the Nigerian economy. Now, the CAC, after recording so many milestones as a result of the passage of the law, including the recent launch of Africa's first Beneficial Ownership Register, BOR. The Commission has recently stepped up its enforcement activities in a bid to further sanitize the business environment and gain investor confidence for the overall growth of the Nigerian economy. In accordance with the provisions of its mandate, the Commission recently announced the commencement of striking off dormant companies from the register. As provided by CAMA 2020, the CAC has the power to suo motu strike off the name of a company from the register where it observes or has reasonable cause to believe that the company is not carrying on business, has not been in operation for a period of 10 years, or has not complied with the provisions of the Companies and Allied Matters Act for a consecutive period of 10 years. Now, Section 692, subsection 3, 4, and 5 of the CAMA 2020, however, mentioned certain mandatory procedures for the CAC as follows. The CAC may publish in at least 3 national daily newspapers a notice of its intention to strike off the company from the register. 2. Where the CAC does not, within 90 days of the last publication, receive any response from the company that it is still carrying on business or in operation, it may strike off the name of the company. And 3. The CAC shall publish in at least 3 national daily newspapers the name of the company and the date of the strike-off. And the law, however, provides that any company, member, or creditor not satisfied with the striking off from the register by the Commission suo motu may apply to the court at any time before the expiration of 10 years from the dates of the publication to get relisted. Wow. Now, for more on this and many others, let's join Mr. Justin Nidia-Biraol, the Director of Compliance, in our interview segment. Do stay with us.
Mr. Nidia Justin Biraol, Director of Compliance, many thanks for joining us on the program again.
Thank you for having me one more time.
Okay. The listing of companies has been in the news for the past couple of weeks, and a lot of people who fall into those categories, I'm sure they're very, very apprehensive. But the question will be, why is the Commission listing companies now? Why?
Well, there has always been a procedure for delisting companies, but part of the reason why we have to do it now is that you recognize from the register of companies that quite a sizable numbers of them have been dormant or redundant. And it's not tidy for the commission to keep inactive or redundant company on its registers.
Okay.
Because it also has a carrying cost.
Okay.
Yes.
So what will qualify me for delisting? Or the conditions that will make the commission to delist me as a company? Is it just because the fact that I'm inactive? Or that I've not paid my
Annual return?
annual returns, yes.
Yes, that's part of it. The criteria is that the company should have been dormant for a period of 10 years.
10 years.
Yes. So if that position is attained, then a company is qualified to be delisted. Yeah.
Okay. We also understand that there are two types of delisting, isn't it?
Yes.
We have the voluntary and the involuntary. So talk us through these types of delisting. So if it is voluntary, I don't need the commission to delist me now. I can just delist myself.
Oh yes, that's what it is. But what we will notice from that is that the process of voluntary delisting came in with Companies and Allied Matters Act 2020. Before the review of the law, the process of voluntary striking off was not there. So it was rather the involuntary type that has always existed since 1990. Yes. So, but for voluntary, the thinking behind it is that one, you might have registered a company, for instance, for a specific project. Then maybe as a result of disagreement between the parties, the company never gets started formally.
Okay.
So sometimes we could have what is called special purpose vehicle, which are registered specifically for specific projects. So if before the project takes off, there is disagreement between the parties and the special purpose vehicle never get operated,
Okay.
then the voluntary striking off will recommend itself.
Okay.
Yeah.
So such arrangement exists.
Such
Special purpose vehicle. So
Yeah.
just register a company just to execute a particular project, and after that, everybody goes
Yes,
their way.
it is allowed that
Okay.
you can register a company to execute a specific project. Once that project is executed, then the promoters will now wind up the company.
Okay.
Yes.
And then they come to the commission?
They come to the commission to wind up the company.
Okay, for
But,
formal.
but for this involuntary striking off now, what it will require is that the company did not at any point in time commence operations.
Okay.
Yes. So for certain reasons, the company
What is the time frame for a company to commence operation from the date of registration?
they can start immediately they are registered. Yes. There is no specific time.
No, if they don't start, what is the time frame that they have to enjoy before they start?
No, under the old legal regime, there was what we call certificate to do business, which was actually restricted to only public companies. But under this new legal regime, the requirement for certificate to do business for public companies is no longer there. So what that means is that as soon as you are registered, you can commence operation.
Okay. So how did the commission arrive at 100,000 companies?
Well, like we said, the basic requirement is that the company should have been dormant for a period of 10 years.
10 years.
Yes. So, and when you go through the data, you could have even more than that 100,000.
Yes.
But the commission is taking them in batches.
Okay.
Yes.
So the starting point is 100,000.
Is 100,000.
Yeah. We do understand that the names of these affected companies will be published, and then an opportunity will be given to people to go and pay their annual returns. But tell us, what time frame will all of that take?
Well,
Between publishing and then final delisting?
Like you have already said,
Yeah.
the list has already been published on Commission's website,
Okay.
and the promoters or the directors and the shareholders are given a time frame of 90 days, which
Okay.
is a requirement of the law, that within that 30 days, if they so desire, they can update their records, which means they should file the annual returns along with what we call PSC requirement. That's beneficial ownership information. So for each of the years that you have been in default, you have to update all of them. Then once you do that, you now inform the commission formally that you have updated your record and that you are no longer owing any arrears of annual return. So the commission will now remove the company's name from the list that has already been published.
Okay.
Yeah.
For some who will say, is it because the commission is broke? That's why you have the listing companies now. Because the commission needs to make money.
No, the listing will not necessarily give the commission any money.
No, I mean for those who will have to come back and pay their annual return.
In the first place, based on experience, only few of them
Will come back.
will come back.
Okay.
Yes.
Okay, so most of them won't come back.
I can assure you that most of them, because first of all, some of the companies are what we describe as briefcase companies.
Okay.
Nothing is being done with them.
Okay.
So those that register them will rather allow them to die a natural death.
Okay, they've already outlived their purpose.
Yeah, they have already abandoned them, so to say.
Oh, okay.
Yes.
Okay. Now, but let's look at the consequences for companies that are going to be delisted eventually. What are the consequences?
Well, once a company is delisted, it is assumed that it is dead.
Okay.
It is dead because what that means is that the company in itself can no longer enforce any rights.
Okay.
And that if that company also has properties, the properties will be forfeited to the federal government. So
Forfeited to the federal government?
Yes.
As a private company?
Whatever it is, whether private or public company.
So my small house will be forfeited to the federal government?
If it is in the name of the company, of course, that's the implication.
But why? I'm a private person. I'm not a government company.
You are dead, and a dead man does not own any property.
Okay.
Yes, that's the implication of.
But a dead man has people to inherit his property, isn't it?
In this case, the law provides, because first of all, you recognize that you before you are delisted, you are also owing federal government.
Okay, money.
Statutory liabilities that you have not discharged.
Ah, okay.
Yeah.
So if I'm wise enough, I'll just sell my house before you delist me. And then I don't have anything.
Well, there is a provision if the law were to be strict, because that's like trying to play the smart.
Yes.
And usually, once an insolvency process is invoked, the company has restriction as to how it will actually dispose of its property.
Okay.
Yeah.
Okay. So what are the consequences? Aside from losing your property, your company is dead, and you have liabilities to pay.
No, that's why we need to draw a distinction there.
Okay.
Because if the company has not commenced operation, naturally it will not have liabilities.
Okay.
That's why a distinction should always be drawn between what is called striking off and winding off.
Okay.
If the company has commenced operations, then it must have incurred liabilities. Okay, and in that situation, it will not be appropriate to strike it off.
Okay.
Yes. So the appropriate remedy will at that time be winding off, in which case you will appoint a liquidator that will pay off the debt and liabilities of the company and also gather its assets. So striking off is strictly for companies that have not done business, or if they have done business for a period of 10 years, they have been comatose.
Okay.
Yeah.
So there's no consideration for economic reasons. that because of the economy, companies couldn't meet up and all of that. There's no consideration for that.
Consideration in terms of
The economic situation maybe forced companies to be dormant.
it is recognized that maybe for economic reasons, the company might have not also commenced business. Maybe what the promoter had in mind was a business that maybe has been overtaken by technology.
Yes.
Or for some other reasons, that business is no longer feasible.
Yes.
Then in which case it will not make any economic sense to actually continue even the idea of the company in the first place. So the best thing is, first of all, either you voluntarily strike it off or you allow it
To go
naturally, like it will now run into about 10 years, at which point it will now be striking off the register.
So now let's come to the remedy or condition for coming back. So a company is struck off today. The promoters can go and register in another name, or they can still come back and register with the same name.
No, it's not registration that is remedy for a company. That registration is always considered as a new thing. If the name is available, you can always register. But for striking off, first of all, you have to make distinction. If it is a voluntary striking off, then the law allows the striking off to be set aside within a period of 2 years.
2 years.
2 years, if there is a need for it. And usually either the shareholders or the directors or any interested party can usually apply to the Federal High Court to have the striking off set aside, or to apply for order of relisting. Once that order is obtained, then you now come to the commission with the order, fill the necessary forms, update your annual returns, which was the primary reason for which the company was striking off the register in the first place. And then with the order now and the application and the payment of a relisting fee along with the annual returns will be restored back to the register.
So that's for the voluntary.
That's for the voluntary.
What about the involuntary?
For,
Any remedy?
for the involuntary, the law allows a period that you can always come back within a period of 10 years.
10 years?
Yes.
So you'll be out of business for 10 years?
That's your choice. That's the maximum period. You can come back immediately if you so desire. But,
I want to come back immediately. What happens?
You go through the process that has been prescribed. You go to the Federal High Court, obtain an order for relisting, like we have said.
That will take time again.
It would not ordinarily, because usually it's what we call ex parte application. Which you don't need to serve anybody. If you have to serve the commission, that's just for reason of courtesy. Usually the commission will not oppose a company that have a reason to come back to be restored on the register.
So you can do that within a month or 2 months or 3 months?
Yes, you can do it anytime after
the official delisting.
After the official delisting. But the maximum period allowed for it is 10 years.
So
after that 10 years,
nothing.
You cease. It's like you are now formally dissolved.
But if I decide to come back in another form?
In which form now?
To maybe register another company.
Of course, the name will still be on the register. So you cannot register the same name.
No, not the same name. Maybe another name.
A person can always register a new company. The fact that you are a shareholder in a company that has been striking off does not necessarily disqualify you from registering a new company. Law has not taken that position yet.
Yes. So I'm saying that instead of me going to the courts, going to follow the procedure that will take, time, why don't I just go and register a new company with a new name?
For strategic reasons, some people may need to come back.
Because they are known for
not only issue of goodwill, which you have already alluded to, there could be a situation in which the company might have acquired property
Okay.
in the name of that company. So if it doesn't, if it's not restored on the register, what it means, like we have earlier said, is that that property is forfeited to the federal government.
Okay.
So in order to
Save yourself.
save yourself and get back the property, first of all, you have to be restored onto the register.
Okay.
So for those and other reasons,
Okay.
there will always be a need for some of the companies to come back.
All right. Mr. Ndia Justin Barrow, always a pleasure talking to you.
Thank you very much.
Thank you.
What a great insight there from Mr. Justin Ndia Barrow. Now hurry to update your annual return before the CAC hammer gets to you. Let's now shift gears to company registration as we show you how to register a limited liability company on your own seamlessly online. Enjoy watching.
Company registration. To begin, reserve the company name that you intend to register and then proceed to click on Start Registration to begin. Step 1. Enter the details of the company. Click on Save and Continue. Step 2. Add the objects of the company. Click on Save and Continue. Step 3. Under Articles of Association, you can either create your own Articles of Association or simply adopt the default Articles of Association provided. You can also edit each part of the default Articles of Association to fit your company's purpose. Click on Save and Continue. Step 4. On the directors, enter the details of at least one director. If you want to hide your residential address from public record, click on the Hide Residential Address from Public Record toggle button. Click on Save and Continue. Step 5. Under Secretary, this requirement is optional for small companies and you may skip the step by clicking on the Click Here link button to proceed. However, if you wish to add a secretary, click on the Add Secretary button, enter the details of the secretary, and click on Save and Continue. Step 6. Under Statement of Issued Share Capital, add the share details and enter details of proprietor and click on Save and Continue. Note, you must allot the entire issued share capital. Step 7. On the persons with significant control, enter the particulars of the person with significant control of the company. Step 8. Under Statement of Compliance, if you are an applicant or an accredited agent other than a legal practitioner, fill in your details and click on Save and Continue, or you can skip this step. Under Document Upload, scan and upload all the documents labeled Yes under the If Required column, and where the documents labeled Optional applies to you, please scan and upload to avoid a query on your application. Click on Save and Continue to preview. Step 9. Preview your entries and if satisfied, click on the Proceed to Payment in order to make payment. Remember to remain on the remitter page after you have received a confirmation of payment. Step 11. After payment, you will be redirected to your dashboard where you will make payment for your stamp duty. After making payment, your application will enter the pending panel on your dashboard under registration. When your registration has been approved, your certificate will be automatically generated on your registered panel where you can download and print it.
What are you waiting for? Please go to pre.cac.gov.ng to register your company. And that does it for this week's edition of the program, CAC Weekly. We do hope you enjoyed watching. Remember, for comments and inquiries, you can please take advantage of our social media handles and call our helpline. On Twitter, it is at CAC Nigeria 1. On Instagram and Facebook, it is Corporate Affairs Commission. Our email is cservice@cac.gov.ng. You can visit our website via www.cac.gov.ng. Our call center is on the number 070-806-29000. Join us again next week for yet another action-packed edition of the program, CAC Weekly. Same time and same station. From me, Amina Jibril, and the whole of the team, it is bye for now.